Intestacy laws in Georgia. When an individual in Georgia passes away without a valid will, their assets are distributed according to the state's intestacy laws. These laws serve as a default estate plan, directing assets to the decedent's closest living relatives in a manner presumed to align with typical preferences. Legal framework governing intestate succession in Georgia. Georgia's intestacy statutes are outlined under Title 53 of the Georgia Code. They prioritize the distribution of the decedent's estate to immediate family members, such as spouses and children, followed by more distant relatives if no immediate family exists. This legal structure aims to equitably allocate assets among surviving kin. Determining heirs under Georgia's intestacy laws. In the absence of a will, Georgia law specifies a hierarchy for inheritance. Surviving spouse and children. If both exist, the spouse and children share the estate. The spouse is entitled to a minimum of 1/3, with the remainder divided equally among the children. No surviving spouse. The entire estate is distributed equally among the children. No surviving spouse or children. The estate passes to the decedent's parents. No surviving parents. Siblings inherit the estate equally. No immediate family. More distant relatives, such as nieces, nephews, grandparents, aunts, uncles, and cousins, may inherit in that order. This sequence ensures that the estate is allocated to those with the closest familial ties to the decedent. Understanding the probate process for intestate estates in Georgia. Probate is the court-supervised procedure for authenticating a will and overseeing the distribution of a decedent's estate. In intestate cases, the probate court appoints an administrator, typically a close relative, to manage the estate. The administrator's responsibilities include filing a petition, initiating the process with the probate court in the county where the deceased resided, inventorying assets, compiling a comprehensive list of the estate's assets, settling debts and taxes, paying any outstanding obligations of the estate, distributing remaining assets, allocating the remaining assets to the rightful heirs as determined by law. This process can be time-consuming and may require the administrator to make numerous legal and financial decisions. The importance of having a will in Georgia. Creating a will is crucial as it allows individuals to control asset distribution, specify how assets should be allocated among beneficiaries, appoint guardians, designate guardians for minor children, express final wishes, outline preferences for funeral arrangements and other personal matters. Without a will, the state's intestacy laws determine the distribution of assets, which may not align with the decedent's personal wishes. For example, a surviving spouse might have to share the estate with other relatives, or if no relatives exist, the state may claim the assets. Additionally, the absence of a will can lead to family disputes and prolonged court procedures, adding emotional and financial stress for loved ones. Ensuring that your assets are distributed according to your wishes requires proactive estate planning. At Trace Brooks Law, we focus on guiding individuals through the complexities of estate planning and probate processes. Our experienced attorneys are dedicated to providing personalized assistance to help you secure your legacy and provide peace of mind for your loved ones. Contact us today at 404-492-9559 or visit us at 1275 Peachtree Street, Nebraska number 525, Atlanta, Georgia, 30309, United States, to schedule a consultation.